back, everybody. Thanks so much for joining us, and we're about ready to start the next session. During this session, the panel will look at Tribunal Deliberations and Drafting an Enforceable Award. The faculty for this segment are Ms. Christine Artero, and Christine had a momentary technical issue. Oh, she's back. She's here. Okay, pardon me. Christine is here. All right, and then in addition to Christine, we have Professor Joongi Kim. We have Mr. Christopher Lau, SC, Mr. Stephen Lim, Arbitrator and Barrister at 39 Essex Chambers, Singapore, Mr. Yoshihiro Takatori, Partner at Kasumigaseki International Law Office, International Arbitration Chambers. And the moderator for this session is Mr. Alan Thambiayah, member of the SIAC Court of Arbitration and council member at the ICC Institute of World Business Law, and independent arbitrator at the Arbitration Chambers. To the panel, please.
Thank you, Michelle. Unfortunately, we can't see all of you who are participating in this session. But let me just say that everything that you have done over the past 2 days, or even those who have done it only today, leads to this point in the arbitral process, which is the award. As you know, 1,000 roads lead men forever to Rome. And in international arbitration, Rome is the arbitral award. That is the document that you want in your hand, which says that you have won. But again, that is easy enough to say, because there's been a lot written about what is this creature called an award. To enlighten us on that, I will invite Joongi to tell us briefly what an award is.
Okay, hi everyone. My name is Joongi Kim. I'm based in Korea, and thank you, Alan, for that. So I'm going to briefly talk about, in a nutshell, what an award is. As Alan suggested, that's where Rome is. So basically for us, of course, in our world, the award rendered by the tribunal is comparable to your judgment rendered by a court. And of course, the interesting thing here is, our Bible, of course, is the New York Convention on one hand, and of course, the widely adopted model law on the other hand. And if you actually look at the convention and the model law, there's actually no definition of an award. And interestingly enough, the drafters, they debated about this. And even particularly in the case of the model law, they actually thought it was desirable to have a definition, but unfortunately, they ran out of time. So they couldn't come up with a definition, and here we are. What I'll try to do, therefore, is I'll try to give you like a rough, general definition. And then, of course, Stephen's going to elaborate this from a different angle. A rough definition would be something like, it probably should have the term award in it. It doesn't have to, but usually, say award, it'll be written. It'll be a written decision by a tribunal, ideally duly appointed, based on an arbitration agreement, and that determines something substantive. And I think that's kind of a general definition if we were to give one. But like I said, most places do not have a definition. But that's, in our world, I think people would agree those are the types of things, if you were to try to come up with one, that's what you'd probably want to put in. In terms of what an award does, I think it's critical that the reason we want an award, of course, is it gives us the New York Convention benefits. So through an award, you can get it recognized and enforced through the convention, through all the convention members. An award, usually, of course, if it's a final award, it'll give you res judicata effect. And then for the tribunal, once they render the award, they're sayonara. They are functus officio, unless, of course, there's special things, but basically they're out of the picture. So that's kind of what an award is, basically, to introduce that. I was also asked to try to provide a short talk on what an interim award versus a partial award is. And the bottom line on this, to make it short and sweet, is I wouldn't stress out about this. Even the model law drafter decided it was too difficult to try to make this distinction. And most statutes around the world actually really don't make a distinction. There are some fine differences. Some say that a partial award is this, an interim award is that. But at the end of the day, it's something that's not a final award that decides something before that. It could be like an issue on jurisdiction, it could be a specific issue. But whether it's interim versus partial, I don't think you should be that stressed out about that. I'll stop here.
Joongi, can I just pick up one point that you raised, which was that the tribunal becomes functus officio. But from the effect of an award, isn't it really the case that whether it's a final award in the sense that it's the last award, every award is final? In that it finally determines a substantive issue that arises for determination in the arbitration. That is the position in the sense that the tribunal is also functus officio in relation to each issue it decides in an award along the way.
So you're in terms of like a partial and an interim award, is that what you're getting at?
Yeah.
That's actually so let's say there's a question on jurisdiction, and they decided to render an award, partial award on that first, and they've rendered their decision an award on jurisdiction. I would argue that until they're the absolute final award, that's when they become functus officio, not when it's the interim or a partial award. I don't think they would become functus officio at that stage.
Yeah, except that, of course, a decision on jurisdiction may not be an award.
Sure, of course.
Yeah. Stephen, any views on exchange Joongi and I have had?
Thank you, Alan. Yeah, I just add some comments on these terms that you tend to see. I agree with Joongi that it's hard to draw a distinction between what is an interim award and a partial award. But you do see these terms referred to, and it's actually in the Singapore International Arbitration Act. The definition of an award in the Singapore International Arbitration Act says an award decides a substantive issue, and then it goes on to say, and includes an interlocutory, interim, and partial award, without explaining what each of these terms mean. And when they list them out that way, it tends to suggest that there is a difference between an interlocutory award, an interim award, and a partial award, but it's extremely difficult to draw that distinction, and particularly the term interlocutory award. As Joongi has mentioned, an award, while there is no definition of an award, of what an award is, and when I come and talk about this later, I'll explain that it's just a very controversial and difficult concept to define. But it's said that it tends, as Joongi said, it said that it has to do with the substance of the dispute, and the distinction is drawn between interlocutory issues. So when the Singapore Act talks about an interlocutory award, you really wonder what that means.
Well, for example, if we can just continue that line for a short while, if there is a bifurcation and there is an interim or partial award on liability, for example, and that was where I thought Joongi was leading us to, that once the tribunal issues an award on liability, it is final as to that issue, and therefore it's res judicata between the parties on the issue of liability, and the tribunal is functus in relation to any liability issues. Any reaction to that?
Well, let me make a comment in relation to that, Alan. That yes, I think that generally it is the case, and in fact, you have section, I think it's 19B in the Singapore International Arbitration Act, which actually then makes it statutory that once an award is issued, the tribunal cannot go back and review it. But it actually arose out of a case where a tribunal did go back and review it, and the legislature thought that then they didn't want that to happen, so they actually put it into the act. I actually think section 19B creates some problems. It creates problems particularly in relation to interim, what you call interim awards or emergency arbitrator awards. So there's a big debate anyway, we get to the fringes here, as to whether an emergency arbitrator can issue an award, but the Singapore Act specifically, well, the SIAC rules specifically say that he can. And the Singapore International Arbitration Act was amended to say that an arbitrator, tribunal includes an emergency arbitrator, would suggest that he can issue an award. But then all emergency arbitrator decisions are subject to review by the tribunal. And so how does that sit with section 19B? I think these are some of the more difficult areas that when you get to these, fine points, these are some of the more difficult areas to resolve.
Yes.
Alan, it's Christopher.
Yes,
can I just add something? It's the point that you raised, which is, is the tribunal functus officio on that issue. Where, for instance, it bifurcates liability and quantum. What I've seen sometimes is tribunals, to ensure it is not functus officio, reserving jurisdiction on the same issue should new facts come to light. And that seems to have worked in some instances. But what it does, of course, is to confirm, what you said, which is the tribunal is probably functus officio on the issues that it has decided on.
Yeah, that's interesting, because if you reserve the jurisdiction to redetermine an issue, if new facts come to light, that raises the question whether your first decision or award is final for the purposes of the New York Convention.
Yes, it does raise that problem.
Yeah, but anyway, one takeaway from our short discussion is that nomenclature, I think, generally is not so important. You can call a decision an award, but that won't make it an award. You have to look at the substance of what is in the document that you are looking at. I'm now going to invite Christine to give us a very brief reaction to the views that have been exchanged, and then to go on to tell us what are the formal and procedural requirements of a valid arbitral award. Christine?
Thank you, Alan. Well, I think as all of you just have discussed, it's quite a difficult issue when it comes to the naming of the award. The simplest way is probably to keep to partial and final, in my views, because you partially decide on something, but it's decided, and final when it's the end of the matter. But in any case, you have to name the award on the front page. So you've got some formal requirements to have a valid award, some procedural requirements. So if we go through the formal requirements, there are very little of them. There are very few. And the main thing you need, the starting point, I think, when you draft your award is to look at the arbitration agreement between the parties. If there is any specific requirement in there, parties can get creative. Most often they're not. The arbitration agreement also will maybe refer to some institutional rules and to the seat of arbitration. So you need to take into account the requirements under the clause, under the rules, and under under the lex arbitri. Those requirements usually come to an award must be in writing, and you must specify what type of award it is, must be dated, because from that there will be all the commencement of time limits for applying for correction or to make applications against the award. It must be signed by all the members of the tribunal or by the majority, with the arbitrator not signing, explaining why. And it must note the place of the seat of arbitration. But you must be, aware as an arbitrator, you must be aware of different requirements. I was looking at the rules of different institutions, and under the GCAA, under Article 63, no dissenting opinion shall be published, right, with the award, which is not under other sets of rules. In Dubai, arbitrators must travel and be physically in Dubai to sign the award, and every single page of the award must be signed. There are different requirements that one should be aware of when they put their award together. And then the last thing is the reasoning. The award usually must be reasoned unless the parties agree otherwise. You find this requirement in most institutional rules. And so what is the reasoning? The reasoning, well, when you write your award for the parties, and to demonstrate that you've given full consideration to all of the parties' arguments, and to explain to the parties why they have, they've been successful or unsuccessful. There is no guidance really as to how you have to reason your award. You can be brief or you can go at length. It is normally quite good practice to keep your reasons concise and limited to what's necessary. That's in order to avoid contradicting yourself or to avoid giving more grounds for parties to challenge your award, I guess. You must base your reasons on the arguments put to you by the parties. But on the other hand, there are many cases in Singapore who said, that you don't have to consider every single argument put to you by the parties. And it's best to keep your reasoning very clear. So clear because it's more likely that it will be accepted by the parties, and it's less likely that it will be challenged. I always tend to write my award for the unsuccessful party. So you keep in mind the unsuccessful party when they will read your award, so that they will understand why you decided that way, and they will be more able to accept it. So that are basically the formal requirements to an award. But then there are many procedural requirements, and that will, as Joongi mentioned, it's all going back to the New York Convention. You need to ensure that you have a proper arbitration agreement. So it's very good practice, if not absolutely necessary, to quote the entire arbitration clause in your award. The subject matter of the arbitration must be arbitrable. So it's also very good practice to talk about the contract and the background of the case and what is the dispute, the subject matter of the dispute. Then there is the whole issue of due process. Due process, having an opportunity to present your case. You've got many challenges of awards on that ground. So it's, again, good practice to set out all the procedural history in your award, everything that happened in the proceedings. And that is especially important when you've got a case with a non-participating respondent. Here, you really have to set out the steps you've taken to ensure that you took all the reasonable steps to ensure that this party was notified that there was an arbitration against them and that they got a proper chance to defend themselves and to present their case. To set out the composition of the tribunal and how the tribunal was appointed, because again, that will show that you complied with the arbitration agreement between the parties, and that's a ground under the New York Convention to challenge your award. And then it's all about answering all the issues and dealing with all the claims and counterclaims put to the tribunal, but not go beyond this. So keep inside your jurisdiction. I think for that, it's quite a good practice to have an agreed list of issues with the parties. It's kind of a checklist, so you're sure you're not missing anything, and you're sure you don't go beyond what's been submitted to your jurisdiction to decide. You have to have a proper dispositive part in your award to show that you've decided everything. That needs to be clear, very synthetic, in a mandatory language. You need to address interest and costs. So everything, because your functus officio once the final award is out, so don't forget interest and costs. And that's about it. I mean, there are other requirements under certain rules, such as, you know, time limits to render the award, sending first to scrutiny to the institution before you publish it. But all of these are more procedural than formal. I think that covers most of it, Alan. You're on mute, Alan.
Thank you, Christine. We are concerned now with the enforcement of an award. And your mention of the dispositive part, the disposition, raises a point on which I would like the views of the other panel members, if they have any to express. And that is, at the end of the day, isn't it the disposition part which says, and hereby, the tribunal hereby, having read all the, you know, party submissions, hereby declare an award and decide as follows. Isn't that really the part that is being enforced? And that is why you have to be absolutely clear in that part. And what happens when you say something in the disposition which is not, does not gel with something that you've said in the earlier part of the award? Have any of you come across any problems like that? Chris, Stephen, Joongi?
I agree with you, Alan, that this positive has to be absolutely clear, because that is the part that is enforced.
I think a good practice is also to be able to read the dispositive part on its own. So, for instance, even if you define the contract in the award, it's good to refer to define what is the contract, or you know, so to be able to read it on its own, and to have again this checklist where you show that you've reflected your findings of every single issue in there.
Right. Thank you. Anybody else? Any views?
Just to add on, Alan, that I agree with you that it is the dispositive part that is the most important part, and ultimately the relief that you're seeking to enforce comes out of that. But there are other aspects of the award which would be important at the time of enforcement as well, because there could be an issue of breach of due process, for example, and then you have to look at the other aspects of the award rather than just the dispositive, because that's when that becomes important. I mean, there is no shortage of ingenuity of counsel for a disappointed party, and we've seen quite a number of cases in Singapore now where the set aside or well, more particularly in Singapore, set aside because Singapore seated, where the set aside application is brought on the ground of breach of natural justice, and one of the grounds is that the tribunal either failed to consider an issue or decided issues not argued by the parties. And when that's the ground, then the rest of the award becomes very important, because the process by which the tribunal took to arrive at the dispositive becomes very important.
Thank you. In fact, we have a question from one of the delegates, and it is this. What types of challenges you fear the most that might render an award unenforceable? Stephen, you do not look like the fearful type, but do you harbor any fears in regard to this sort of thing, lurking in the background of your mind that makes gives you a sleepless night, and have I done something wrong with an award?
Well, perhaps fear is not the word, but what I'll be most alive to is what I mentioned, two aspects arising out of the fundamental principle of natural justice, that parties must be given the opportunity to be heard, or in other words, must be given due process. And these two are the 2 points I've mentioned. One is that the tribunal has failed to consider all the issues that have been put before the tribunal, or the tribunal has ended up deciding on points not argued by the parties, both of which would be breaches of natural justice and may put the award at risk of being set aside or not enforced. Let me take the second point first, because that's probably an easier one, which is deciding on points not argued by the parties. I mean, Christine said that a tribunal should decide on the issues put before them, and that's right, except that, you know, when the tribunal is aware, I mean, there is a principle, particularly in, I think, in civil law, that the tribunal is taken to know the law. And if there is an important issue that is relevant to deciding the case and you feel that that's not been adequately addressed, I don't think you are necessarily confined then to just what the parties have put before you. If you think that there is an important issue that should be raised, you can take that into consideration, but the very, very important point is you have to raise it to the parties. You have to tell the parties that I believe that this may be an issue that needs to be addressed. Please address me on it. Now, if you put it to the parties and given them the opportunity to comment, then the breach of natural justice point is taken care of, because you've given the parties an opportunity to be heard. And I think you should do that. If you're of the view that the parties haven't adequately addressed the issues and it is highly material to your decision, I think you should do that. The second point may be, or what actually I listed as the first one, which is failing to consider all the issues before the tribunal, may be a little bit more of a complicated one. Because this sometimes involves drawing a distinction, a fine line between what is called disregard and misapprehension. And there's a case, a Court of Appeal case in Singapore that deals with this, which is AKN and ALC. And the court explained it in this way, that there is no breach of natural justice if a tribunal misunderstands a party's arguments or disagrees with it. So if it's just a point that the tribunal misunderstood it, got it wrong, there's no breach of natural justice, because unfortunately, you know, it's famously said by a very well-known arbitrator that, well, unfortunately, when parties agree to arbitrate, they agree to let the tribunal, you know, get the law wrong. However, there's a breach of natural justice if a tribunal fails to consider an argument made by a party. Best for me to explain this using some examples. So as I mentioned, there were two cases in Singapore. One is Front Row Investments Holdings and Daimler East Asia Private Limited. In that case, the tribunal, in Front Row, the tribunal had mistakenly found that a party had conceded a number of points in the arbitration, and therefore did not consider these points when making the award. And the court found that the tribunal did not bring its mind to bear on an important aspect of the dispute and therefore set aside the award. And similarly, in AKN and ALC, the tribunal mistakenly thought that a party had conceded it would not be able to fulfill a certain obligation by a certain deadline, and on that basis held that the party had breached the agreement. The tribunal failed to consider the party's argument that the obligation had not fallen due, and therefore there was in fact no deadline to meet. And that part of the award was set aside. So, you know, and the tribunals in these cases were made up of very eminent arbitrators. So it can happen to the best.
That's very illuminating, Stephen. Thank you for that. And I could just add to that very quickly that in a very recent English decision, an award was set aside because a panel of eminent arbitrators reached a decision in the process of reaching the decision, reversed the onus of proof on the parties. And the English court held that that was just, you know, beyond the pale and set aside the award. But coming back to this point about orders as opposed to awards, we have a question here from a delegate, and I'll just read it out for you. Some arbitral tribunals issue an order instead of an interim award, especially in cases of interim or conservatory measures. What will be the difference in the enforcement aspect of an interim order and an interim award in enforcing, say, an injunction or other similar measures? So, Stephen, would you like to take this up? What is it? Is an order, to put it shortly, is an order of the nature described by the delegate an award?
Yeah, well, this is a difficult subject. And the answer to some extent depends on what is actually the subject matter of the order. I think there is a clear distinction between orders which are merely directions, timetabling. That clearly isn't an award. But there are orders that you mentioned, Alan, like deal with interim relief, like interim measures, stay of arbitral proceedings, or some people say even document production, that to some extent, these do deal with substantive matters. And there's a real debate as to whether these constitute awards. I mean, focusing on interim measures, which you've raised, as Joongi mentioned, at the time of there was no definition of an award. And the Artero tried to come up with a definition of an award at the time the model law was being drawn up, but they were not able to. And one of the issues really was, well, two things. One you mentioned was the question of jurisdiction, and the other one is also interim measures. There was really no agreement on whether these could be constituted awards. Coming back more to a practical issue then, which is really the question of enforcement. There's a real, I think that there's strong wellspring of commentators which actually say that interim measures can qualify as awards and should be enforced as awards. There are some jurisdictions which would enforce interim measures as awards. There are a number of US courts which have enforced interim measures as awards. On the other hand, there are a number of jurisdictions which don't. There is, though, an agreement, I think, while there is disagreement as to whether an interim measure could be an award, there is agreement that interim measures should be enforced. And measures have been put in place to try and do so. Jurisdictions have enacted legislation to enforce interim measures. Hong Kong and Singapore are amongst these jurisdictions. And there's also the 2006 amendment to the model law, which has a specific provision dealing with interim measures and also dealing with the enforcement of interim measures. So it actually sets up a parallel regime of enforcing interim measures, similar to the New York Convention and similar to the grounds of the New York Convention. Unfortunately, though, I think only about slightly under 30 countries now apply the 2006 amendment. So that's not as wide in application as the model law itself. So that's one of the issues that we have to deal with.
Yeah, and harking back to what Joongi said at the beginning, an award deals with an issue of substance, a substantive issue. And when that determination is made in a document, the tribunal is functus. And my reaction has always been that, well, that cannot be said of an order or direction dealing with interim measures, because the whole nature of interim measures is such that a tribunal can revisit it in new circumstances. So I'm not sure whether the panel members have any views on that. Chris, do you have any views?
No, I share the view you expressed, Alan. There is some uncertainty.
Perhaps we can get a view, Yoshi, from you.
Sure.
And what is the Japanese experience? How has Japan tackled the enforcement of interlocutory orders or by arbitral tribunals?
Right. Thank you very much. It's deeply related to the such distinction between the award and the interim, kind of order or such kind of a concept. And a little bit getting back to the such definition matter. Some academics saying the such definition does matter, and the others saying that doesn't matter. So that's deeply just practically whether it's enforceable or not, depending upon the jurisdiction, should be the matter. Then for such interim order or preliminary measures or something is a quite hot argument now in Japan related to the 2006 ancestral model laws type of amendment should be implemented, imported to the Japanese Arbitration Act. That's the current status. The argument is the kind of comparing with the kind of a judgment by the litigation, whether such the interim measures should be enforceable or not. And under current Japanese Arbitration Act, it's not that directly enforceable under the New York Convention, but in accordance with the Ancestral 2006 amendment, now quite strong argument is the assertion is the, okay, we should have a such enforceable system to be inconsistent with the 2006 ancestral model law. So the scope of such interim measures should be limited to the such order which is ordered by the arbitration of the seat of Japan, or outside of Japan seat can be also could be covered or not. That's the one kind of argument going on. But anyhow, the such, you know, the matter is the it's not the matter whether the definition itself, or practically speaking, the such interim measures can be enforceable or not. And then now the Japanese government, Japan Federation of Associations, and the Ministry of the Justice now kind of planning to amend the Japanese Arbitration Act. That's the current status. And I agree with the Chris and Stephen. The according to the such, you know, the definition whether it's substantive or not. Again, the such interim measures could involve such substantial issues, substantial matters as a tentative one, then finally could be decided. But the current Japanese argument is the for promoting more like a arbitration friendly platform by which, you know, we are now established the JIDRC or JMC Kyoto or something, then quite positive positive side on the such amendment. That's the current status. Thank you.
Thank you, Yoshi. Joongi, can I come back to you? What about the position in Korea? Are they joining the party?
The short answer is we're among the 30 countries that Stephen mentioned that have adopted the 2006 version.
Right, and is that wide enough? Because this is a point that Yoshi touched on. Is it wide enough to embrace interim measures, orders made by tribunals in a different seat, but they're seeking to enforce it in Korea?
Yes, yes. Mm-hmm.
Okay, all right, that's good. That's good. Because I think we can now move on to another important aspect of awards or decisions or orders, especially in the case of a three-member tribunal. You know, I think we all have come across sole arbitrators walking around, talking to themselves and muttering to themselves, and people wonder what they're up to. That is a process of deliberating with yourself. The point of a three-member tribunal award is that it expresses the collective decision of the tribunal. The question then is, how is that collective decision arrived at? Perhaps we can start on that topic. If I may, Chris, invite you to tell us about deliberation and what is the purpose of deliberation and what aspects of deliberation are important.
Thanks, Alan. Although I should say before I start on that I've seen many sole arbitrators become schizophrenic. I think to determine the purpose of deliberation, it's helpful to ascertain what the word deliberation means. The Oxford English Dictionary refers to it as a careful consideration, or a discussion of the reasons for and against. This points us in the right direction, which is that the purpose of the tribunal's deliberations is to carefully consider and discuss the reasons for and against in order to come to a decision. What the tribunal deliberates on is not limited only to matters that are in dispute between the parties, namely the merits, or even on procedural matters, but they can also include matters that are within the tribunal's prerogative. As an example, in order to protect the composition of the tribunal and prevent conflicts of interest from arising, which ultimately could derail the arbitration or affect the legitimacy of an award, tribunals often provide in the first procedural order that a change of counsel or solicitors or the legal representation of a party requires its approval. Such an approval in turn requires, as in the case of disputes on matters of merit or procedure, that all tribunal members must have the opportunity to participate in the decision-making process. And if I can go on, Alan, to the next point as to why they're confidential. It's so obvious that deliberations must be confidential that the question as to why they are confidential does not immediately spring to mind. But knowing the answer to this helps to understand the danger that a leak poses to the integrity of an award. Deliberations must be confidential because if a party knows in advance what the tribunal has been discussing, as well as the views that have been exchanged amongst the members, that places the informed party in a far better position than an uninformed party. The informed party could then, for example, either attempt to influence the outcome of the deliberations by adapting its submissions or to try and reach a settlement with the uninformed party on terms more favorable to it than what the tribunal would have decided. Obviously, therefore, any leak of the tribunal's deliberations puts the parties on an unequal footing. There's one other aspect on how deliberations can have a negative impact on the integrity of an award. This aspect has its roots in the view that the arbitrator's duty of deliberation is based on international public policy, as so aptly summarized by Yves de Rennes when he said, in the absence of deliberation, the decision would not be taken by the tribunal, but by one or two individuals abusing of the power conferred to them as members of the tribunal. In such a case, it must be obvious that international public policy would be violated, putting the award at risk, as it did in a very well-known Spanish Supreme Court case of Puma against Estudio 2000. And in that case, in the final stages of deliberation, although one tribunal member had a view different from the other two tribunal members, these other two tribunal members in the final stages met without notifying that other member, finalized the award, and released it to the parties on the same day. The award was annulled, not surprisingly, and the Supreme Court concluded that the two tribunal members were liable for excluding the third member from the deliberation procedure. Why is that important? The decision itself, which resulted in the Supreme Court deciding that the two tribunal members should be responsible for the cost of the arbitration, which was not an insubstantial sum. It was about euro 1.5 million, euro 1.5 million would have to be paid by these two other members.
Okay, that should be serve as a warning.
Yes.
Now, just coming back, Chris, you made the point that it is so obvious that deliberations must be confidential. What about, sort of sidebar chats? People do this, as you know, tribunal members either in the hearing room or just outside the hearing room will huddle together and chat about something that has arisen in the course of the hearing. That those sort of chat sessions would also be covered by confidentiality, would they not?
Yes, they would.
Yes,
Yes, they would.
I would have thought so. No, it's just that somebody said about the ingenuity of lawyers, and that was an example that sprung to mind. But there's another aspect that you touched on, Chris, that perhaps we could elaborate on briefly, and that is the situation of a rogue co-arbitrator, a non-participating co-arbitrator. I mean, I think we all know that it is not unknown for parties to appoint an individual who is partisan.
Yes.
And I mean, and I can give you an example to serve as the basis for reaction from you all. And that is when the co-arbitrator sort of made himself scarce immediately after the hearing and couldn't be contacted for several days to enable the chairman to arrange for deliberations. And finally, when he was tracked down, he was on board a cruise ship. And he said, you know, I'm on a round-the-world cruise and I'm going to be otherwise engaged with my family for 3 months, and very difficult to communicate with me on a ship. And so I'll see you guys in 3.5 months or so. I mean, that's a sort of, how do you ensure that you don't get stymied by a co-arbitrator who refuses to be drawn into deliberations by fair means or foul? That's really the question, Chris.
I know it. I think that is a. I mean, this is what we all refer to as the dark side of arbitration. It is difficult. It is difficult. One way, of course, to address it is to maintain communications in the sense of even if they remain unanswered, making very clear at some point, ideally early on, as to what the means of communication is between the tribunal, whether by email or fax, something that can be recorded, and continuing, I suppose, to send, on writing to this recalcitrant arbitrator on all matters in respect of which his input is required. It's been suggested that in a very severe case, in an extreme case, and if it involves an institution, to copy the institution in, so that it's made clear that that arbitrator is deliberately not participating in the process. But it is a difficult problem.
All right, thank you for that. Any other reactions to this scenario, Christine?
Well,
please go ahead.
I was thinking also during the process. I mean, I've seen tribunals where arbitrators are completely unresponsive. So not only during deliberation, but also during the entire arbitration. So it's a problem that may happen at different stages of the arbitration. And I think Chris made a point. When there is an institution involved, it's good to copy the institution so at least they know what's going on, because also it reflects badly on the presiding arbitrator, right? But I mean, in my experience, in what I've seen around me, it's when somebody is just not replying and you've got urgent matters, you send them an email and then another where you say, well, if I don't hear from you, we'll just proceed. You try to call, but there is so much you can do, and the show must go on. But when it comes to deliberation, it's much more difficult.
Yeah.
I mean, Alan, I had one instance when we were trying to fix hearing dates, and I had this co-arbitrator sitting next to me who was clearly partisan, and we were trying to take dates, and he pulled up his diary, and I said, "Are you free next month? First week or second week?" And he opened up his diary, not realizing that I could actually see what was in his diary, and it was blank. And he said, "I'm not free." What do you do in that case?
Oh, seems to be quite mild, that. Any other experiences, on how to deal with this sort of difficult situations? Stephen, Joongi?
I think it is an extremely difficult situation. I think it has to be dealt with delicately and carefully.
Yes.
That's the main thing, and I'd agree with Chris. This, unfortunately, is the dark side of arbitration. What you can do at best is like what Chris said, is bring it as much as you can. If there's an institution, bring it to the attention of a body that's independent of the tribunal, that can see that that's actually what's going on. But unfortunately, there's not that much that a tribunal can do in those circumstances.
Yeah.
Yeah, I've had a slightly different example, just to throw something in, is I was sitting as a co-arbitrator, and this is not actually so much of a dark side, but the chair was obviously too busy, and he just wasn't delivering the award. And the co-arbitrators were actually very diligent, and we're trying our best to get the chair to conclude the award, but he just wasn't responding, and he just kept on delaying. Not because he wanted to deliberately do so. It's just that I think it was just a matter of priority. And this was a very difficult thing for us because it looks bad on the entire tribunal, because the entire tribunal is delaying the award. And it's like, when we would work so hard, why should we suffer that reputation when it's the chair's at fault? Yes. So I think that's kind of a different situation that comes up occasionally.
Yeah.
I mean, I had one like this, Joongi, and what the tribunal, we were co-arbitrators. What we did was we then drafted the award, and we sent it to the chair and said, "This is the award we propose to issue. Can you please come back within the next 2 weeks?" And he did.
Wow.
Fortunately, he agreed with the draft.
Yeah. So I actually didn't think about that, but of course we were debating as to how far we should get the institution involved as well. And we ultimately did, and that started to trigger things to occur more quickly.
Yeah, yeah. Now we have a question from a delegate. I'll just read it out. It says, please also address concurring and dissenting opinions in awards. Well, I think we all know that the dissent or separate opinion is not an award, and it should not form part of an award. But what is your experience when it comes to dissents or minority opinion? Chris?
If I think it was an institutional award, I leave it to the institution as to whether they want to include the award as the dissent as part of the award or not. Some institutions do.
Yeah. Is there a convention that if the decision of the majority is something that any reasonable tribunal could arrive at? In other words, the conclusions cannot be seen to be perverse or wholly unreasonable. You should not. The third arbitrator should not issue a dissenting opinion. It's unnecessary for him. And apparently there's a convention in Europe that you should not even be seen to be dissenting. Has anyone come across that sort of situation?
I've not.
Stephen, Christine?
I've not come across a situation, Alan, but I think related to what you said is the question of whether a dissenting view can be incorporated into an award. I think there'll be certain issues that an award may deal with many issues, and maybe certain issues on which there may not be a unanimity as to views. And I've certainly have asked in the past that the chair would incorporate within the award that on a particular issue there was only a majority view on that. And I think that has been done, and I don't see any objection to that. At least it shows that the issues have all been carefully considered and ventilated.
Yeah, that's not uncommon, I think. That's not uncommon. But I think one important takeaway is that deliberations are really quite important. And I think I'm going to invite Yoshi now to lead us into this aspect, to tell us what is necessary for there to be effective deliberations, both for in-person hearings and virtual hearings.
Yeah,
Yoshi?
Yeah, thank you. Little bit related to the previous questions, how to avoid such kind of dissent or something. So definitely such effective deliberation would be the key. And so how to proceed with the deliberation efficiently, considering the goal of the deliberation, like Chris mentioned. So first of all, share the common understanding of the purpose, the goal, to find the facts and interpret in due course the legal, based upon their consensus, and then needs to understand the difference, like among the tribunal, such as for sometimes, for cross-border case, like a common law background and civil law background, even interpreting the same governing laws rather than the continuing argument each other. So the efficient communication, organizing the issues, facts, and clarifying the agreed points and disagreed points, and seeking for their consensus as the tribunal. And then maybe usually the chair should take a lead, and how? So maybe usually it's the strongly, but some depending upon the tribunal logistics, of course, such deliberation style could be different, but hopefully they prepare a basis for discussions, and such as a working paper, like a draft, and a chart of the issues, which should be very helpful based on my experience. And then uniqueness and the recommendations for virtual deliberation, especially under the COVID-19, but even after the COVID-19, maybe separate channel and or private chatting, remote with the technology support should be nicely arranged. And then such argument, of course, you should keep the confidential, but should be recorded if the arbitrary tribunals agree upon, of course, confidentiality. And then so what platform the online devices, administration, and technology support are available globally. So of course the SIAC and the Maxi Chambers, and recently the JIDRC in Japan, and Osaka, Tokyo in Japan, which can function as the hub facility. So there can be a sort of the default device, even as a partial version. But for deliberation, such technology support is a very, very essential. And the confidentiality issue, as you may be aware of, the ICA New York City Bar CPL Cybersecurity Protocol for International Arbitration and Mediation 2020. So not just the technology side, but also for the soft side, for the arbitrators and the parties should keep, for keeping the confidentiality, especially under the current cybersecurity attack. Very, very severe fear. That's kind of a soft aspect that should be taken care of, not only for the deliberation, but also for whole procedure. That's from my end. Thank you.
Thank you, Yoshi. And I'm not sure what your collective experience is, but a lot of people think that deliberations happen only after the hearing and when the chairman has circulated a draft. But in effect, I mean, don't you deliberate at least 2, 3, maybe even 4 times?
Yeah, I think the pre type of even before the procedure and the procedural hearing or something, then we just discuss on what should be the issues, and what is already agreed and not, and what would be the key issue or something. And such is a very, very should be helpful for having the effective procedure hearing and also the hearing itself. Because if you just proceed with the huge discovery first, okay, let's proceed with the discovery. That's bad. I mean, such a pre-type of the deliberation is really helpful. And from my case, from time to time, to like 3 times or 4 times. That's deeply depending upon how the complexity of the case and how the speed should be necessary. Like for high-tech transaction dispute resolution, that's very, very fast. Otherwise, the both parties could be facing the chaos in the legal market. So in such case, like a pre-deliberation would be more useful, I think.
Thank you, Yoshi. I mean, we have a few minutes left. Joongi, do you have anything to add by way of your experience?
One thing just I'd like to add in our virtual world, and which I find effective, and what I do when I'm chair is actually I set up a chat room. I find usually in WhatsApp, because it seems to be widespread, or Line or Kakao or whatever, and just among the tribunal members. And I find that to be fast and efficient and effective. And Zoom and WebEx, so that's fine too. But just having the immediacy and the I think the access, I find it to be highly effective. And I think post-COVID and pre-COVID, there's a dramatic difference as to how effective that is.
Yeah. So you're talking of a WhatsApp chat group to be used in the course
just
of
by the
hearing.
tribunal members. Yeah.
Yeah.
No,
So
during the before and during and after. Yeah.
I know that's an excellent idea, except that when you get a co-arbitrator like me, I don't, my phone doesn't ring, or I don't hear it, or I don't see it, and then the other 2 arbitrators are all anxiously waiting for me to respond.
Well, it's not for everybody.
Yeah, but finally I've learned that I should keep an eye out on the phone. And that's what the WhatsApp chat is for. Okay. Anybody else got anything to add or contribute before we bring this session to a close? And I hope it has been of some use to the 58, 57 participants. If not, then that just leaves me to thank all the 5 panelists. You've really contributed little gems for the participants to think about and to take away. Thank you very much.